Attorney General, you were a line assistant at U.S. Attorney for years and a federal judge after that. You have significant experience with the processes surrounding criminal investigations. Tell me, what's the normal process for obtaining and executing a search warrant?
You go to a federal judge, you present an affidavit which you believe constitutes probable cause. The federal judge looks at it, makes a determination of whether it does constitute probable cause. He then signs a search warrant, and it's then executed.
And what's the purpose of a search warrant?
The purpose of a search warrant is to find to find evidence of a crime for which there has to be probable cause that it's in that location.
When executing a search warrant on a location that may contain evidence of a crime, what benefits are there for doing so without notifying the putative defendant or the target of the investigation or his attorney ahead of time that execution of the search warrant is forthcoming?
Sometimes you make notifications, sometimes you don't. If you think that the person who has the evidence of a crime is obstructing justice or is going to move the evidence or will secrete it, if you warn them in advance, then you don't give it. If you don't have those concerns, you may give advance notice.
Yeah, so in the instance of not withholding notice, you do so because sometimes they're going to actually move the evidence if you give them a heads up, correct?
It's a general hypothetical matter, yes.
And in most instances, in your experience of decades of law enforcement, have you seen that more times than not, you give a heads up to the defendant, or is it odd to give a heads up to the defendant?
I can't actually make a statistical resolution. I think it's the case that the government tries to use less intrusive methods if they can, and if they can't, use more intrusive and more emergency methods.
I agree with that. But typically, when you're going to execute a search warrant, typically, I think people would understand this from common knowledge, you would not actually give the heads up. Would you agree with that?
I think as a general matter, that's correct.
IRS Supervisory Special Agent Gary Shapley, one of the whistleblowers, testified that AUSA Leslie Wolf told investigators, quote, optics were a driving factor in the decision not to request a search warrant for the guest house at the Biden's Delaware residence where Hunter Biden had stayed for a time. AUSA Wolf further told the investigators that, quote, there was more than enough probable cause for the physical search warrant there, but the question was whether the juice was worth the squeeze. And she further said, quote, a lot of evidence in the investigation would be found in the guest house of former Vice President Biden, but there is no way investigators will get that approved. Now, do you agree with Ms. Wolf that optics of an investigation should be the driving factor in law enforcement decisions when investigating potential crimes?
I have to say again, as I said before, singling out assistant U.S. attorneys is a dangerous matter. The supervisor of that case is Mr. Weiss. He is the one who made decisions in that case. He is the one who can answer questions as to whether those things happened or whether they didn't.
So let's take her out of the equation then. Let's just take the statement generally. Do you believe that optics of an investigation should be a driving factor in law enforcement decisions as to whether or not to execute a search warrant or not?
The Justice Department has standards for its work, and improper considerations are not part of those. The only questions are those driven by the facts and the law.
Mr. Shapley also testified that AUSA Wolf objected to a search warrant IRS investigators requested for a storage unit purportedly containing all of the documents from the vacated office of the law firm owned by Hunter Biden. Investigators scheduled a call with U.S. Attorney Weiss, who agreed that they could search the storage unit if it remained abandoned for 30 days. But immediately after the call, investigators learned that AUSA Wolf had reached out to Hunter Biden's defense counsel to tell them about the storage unit, effectively ruining investigators' chance to access potentially critical evidence. In your experience, as you said earlier, this is not the typical thing that happens, correct?
Look, once again, I don't know anything about these allegations. I don't know whether they are correct or not. These are questions most appropriately put to Mr. Weiss at the appropriate time and to be covered in his report if he thinks that's the appropriate way to resolve.
Can you conceive of a reason why Mr. Weiss or Ms. Wolf would have given a heads up to Hunter Biden's legal team that the search of the storage unit was forthcoming?
I'm not going to get into hypotheticals about this.
For somebody that was involved in the investigation at that point, who was literally delaying obtaining potential evidence in the case, do you think it was appropriate that then she was involved in the negotiation of the IRS deal with Hunter Biden?
I'm I'm not actually following the question. I'm assistant U.S. attorneys who participate in investigation, also participate in prosecutions. Is that what you're asking?
Attorney General, I
may have
appreciate your
misunderstood.
time here today, but I'm concerned that these facts are just some examples of what's been going on here where, I apologize, I know my time's out. I yield back. Thank you for your time.
The gentleman's